Both sides ready to proceed?
Yes, sir.
All right, that sounds good. Each side will have 15 minutes, and the appellant may reserve up to 5. So we're ready to listen. And you are being videotaped, so we want you to stay there. And
Okay.
I know this doesn't pertain to you, but I'm going to try to get you out of saying it all the time so I don't forget, and that is if there are any children involved, we do not use their names.
Sure.
Thank you.
May it please the court, my name is Brian Unger. I represent the appellant and Cindy Gotham in this matter. Just to start, this is an issue of contract interpretation. It's really just a basic issue of language interpretation. We proceeded right to motions to dismiss after the complaint was filed. So, as far as extrinsic evidence, there's none of that we can really reference here. It's just purely language employed in a contract. So the contract my clients entered with the appellee was for a basement foundation repair job that my clients were not satisfied with. On the first page of this contract is a sentence stating, "This agreement contains a binding arbitration provision which may be enforced by the parties." And on the second page, there's a provision stating that the claims and controversies shall be settled by arbitration, which is to follow the construction industry rules of the American Arbitration Association. In opposing the appellee's motion, we took issue with the provision on the first page, which I called the first provision, the one that just states, "This agreement contains a binding arbitration provision which may be enforced by the parties." We argue that this provision, and namely the phrase, "may be enforced by the parties," and more specifically the use of the parties, could reasonably be interpreted to mean both parties must agree to arbitrate. We argue the phrase is ambiguous because it is capable of at least two reasonable interpretations, and we do submit that one of those reasonable interpretations is either party may enforce the arbitration provision, and the other is that both parties have to agree. So the trial court made a couple findings, held that the phrase is not ambiguous and that it's merely a notice provision, that it merely notifies the buyer of the arbitration provision on the second page or the second provision. But then the trial court also stated that the use of the word "may," and I quote, "expresses the possibility that the parties could utilize arbitration to settle a claim arising from the contract." So I agree with that. To me, that means that that phrase, the first provision, goes beyond mere notice and is actually operative in the contract, and that the second provision is not mandatory, and that somebody has to enforce it, but I'll get to that in a second. So the two findings we're challenging on appeal are, first, the finding of no ambiguity, and second, the finding that the phrase is a mere notice provision. So I'll address both of those in turn. But firstly, I'd like to state that though we raised it at the trial court, we're not challenging arbitrability here. I know there's a presumption that arises when we challenge arbitrability of claims in favor of arbitration. We're merely challenging whether the parties actually agreed to arbitrate, just the contractual language itself. And obviously, we're arguing that our clients did not agree to arbitrate and that the contract calls for agreement to both parties. And in saying that, I don't think there can be a presumption of agreement to arbitrate, so that's just why I'm focusing on the analysis of the contractual language. So the first issue is ambiguity, and that's the state law principle at issue. A phrase is ambiguous if it is susceptible of two or more reasonable interpretations. So the main question is the phrase "may be enforced by the parties" reasonably susceptible of the interpretation that both parties must agree to arbitrate? If it is, and it's also susceptible of the other interpretation, then legally, under the standard, it's an ambiguous phrase. And a little bit to back that up, why I take my position that I think it is reasonable to read it in the sense that it calls for agreement of the parties, because when you look at the contract, which is Exhibit 1 to our complaint, the only instance where the parties is used collectively is in that provision. Every other time there's a separation. It's buyer-seller, buyer-contractor, each obligating one to a certain whatever in the contract, except for the first provision in the arbitration, the first arbitration provision, which uses the parties, may be enforced by the parties. So I think it's reasonable if that means the parties collectively, or could at least be interpreted as that. And I think that's evidence of intent. It's basement care's contract, yes, and since we're only looking at the language, I think it's only reasonable that maybe they did intend to have agreement of the parties if this was to go to arbitration. Otherwise, I mean, it could have been clarified in a couple different ways. If it was intended to mean either party could enforce it, the phrase could have merely said, may be enforced by either party. It doesn't say that, and I, also submit and acknowledge that it could also say by agreement, but that's specifically why the phrase is ambiguous. It just doesn't say it. It just says may be enforced by the parties. So if the phrase is ambiguous, the second state law principle that comes into play is the ambiguity must be read against the drafter. Again, a quick look at the contract shows you who the drafter is. It's Basement Care. Their registered trademark is on the top. It's obviously a form contract that's made for any customer that they pick up. So it should be, if there is ambiguity, it should be read against the drafter and in our favor. So that's the first part of the argument, is ambiguity. The second, as obviously I have to address that it's not a mere notice provision. So again, I think the drafter's choice of language weighs against the trial court's finding on that issue. Again, to go back to this argument, if it was a mere notice provision, they could have easily just wrote, the agreement contains a binding arbitration provision, period. The fact that it goes on to say, which may be enforced by the parties, I think makes the phrase operative, brings it beyond a mere notice provision, and the trial court acknowledged that. Because the arbitration, the second provision states nothing about who can enforce it. Also, the second provision contains very strict language. So if the first provision gave mere notice, leaving only the second provision, there's no doubt it would go to arbitration. But since the trial court acknowledged that the first provision expresses the possibility that the parties could utilize arbitration, meaning that it has to be enforced by somebody, or it has to be, someone has to say we want arbitration, or both parties, as we're arguing. The point is, it's not automatic. It doesn't just happen. It's, there is a possibility that they could litigate rather than arbitrate. So the question is, who can enforce the provision? The answer is the parties. And the ambiguity is in the meaning of may be enforced by the parties. So I know that Appley argued if the phrase means both parties can agree to arbitrate, then it's superfluous because the parties can always agree to arbitrate. That's true. And the trial court found that absent an actual arbitration provision, and the first provision would be meaningless. But both of those arguments, I think, ignore that the second provision is there. Since the second provision is there, it's easy to see how the first modifies it. And I think it's reasonable to read it as, if both parties agree to arbitrate, then arbitration will be run according to the second provision. And to just read it in isolation, the first provision in that sense, is not giving full effect to all of the language in the contract. So the first provision doesn't just say the parties can arbitrate. It says if they can agree to arbitrate. Again, if they do, we'll follow these rules. And I guess lastly, the ambiguity argument can be applied to the first provision as a whole. And I think I just pointed that out. You can say it's just a notice provision, or you can say it's operative. It's kind of, it is sort of ambiguous in that sense. But I know the Ohio law is is you're supposed to give full force to all provisions in a contract. I know this court just held the same recently in Clark v. Corwin, which is 2018 Ohio 1169, citing Delic DC Construction Company v. Nicholas, which was also an opinion of this court. So you can ask, what the purpose of a provision stating, or what is the purpose of a provision stating the parties can arbitrate, if they can always arbitrate. But my question is, what is the purpose of a notice provision when the law is a signer agrees to all terms in the contract?
Counsel, I don't know that you retained any time or you asked for any time, but you are at 4:45 now remaining. Do you wish just to continue or do you wish to say sorry about the time?
Yes, thank you, Your Honor. I would like to reserve the remainder of my
Okay,
time.
sounds good, thank you.
If I may please the court, Your Honor, my name is Dean Constant, and I represent the defendant appellee in this case, Basement Care, Inc. The contract between the plaintiff and Basement Care is a simple two-page agreement. The first page is basically the scope of the work and the signature lines. On the second page are the terms and conditions of the contract. Immediately above the signature lines, the contract states this agreement contains a binding arbitration provision which may be enforced by the parties. The actual arbitration clause found on the second page states, and I will quote, "Any controversy or claim arising out of or relating to the contract and/or agreement or breach thereof shall be settled by arbitration in accordance with the construction industry rules of the American Arbitration Association, and judgment upon the awards rendered by the arbitrator or arbitrators may be entered in any court having jurisdiction thereof." The typical arbitration provision that you see all the time. Plaintiff appellant is not really disputing the actual arbitration provision. I think what they are arguing before this court is that the notification provision on page 1 above the signature lines somehow modifies the intent of the parties as to whether or not there should be arbitration or not. More specifically, plaintiff appellant is asserting that this provision is ambiguous and that the term "may be enforced by the parties" can be construed to mean that both parties must agree to arbitrate, otherwise the arbitration clause cannot be enforced. The trial court stated in its opinion the provision is not ambiguous, and its meaning is that the parties may resort to arbitration to resolve a contractual dispute. Undoubtedly, a party to a dispute with a mandatory arbitration provision can do one of many things: formally resolve the dispute, file litigation, initiate arbitration, or initiate some other type of dispute resolution. Nevertheless, the other party may always enforce the mandatory arbitration provision. So the reason I'm explaining this to the court is that using the term "may" is typically meant to say no one is forced to automatically go to arbitration. But what the law says is that if one of the parties mandates arbitration, the other party cannot override that.
Well, counsel, does not it sounds, you'd say mandatory, and I was thinking the same thing. When I read the court's judgment entry, I didn't see within that the word mandatory. I saw the recitation of the two sections at issue here, where it says in a second that any controversy shall be settled by arbitration. That means, to me, absolutely, there's no arguing about who wants to go to arbitration, whether one person can enforce it or two people can enforce it. You have to. And then we have the notice provision right above the signature line that says may be enforced by the parties.
I'm not certain exactly of the language. I have to look at the trial court opinion, but I think to answer your question is that you have to realize that if there's an arbitration provision, the parties do not have to arbitrate, if they both agree to that. So it's not a mandatory provision, meaning that you can't talk about the case, you can't settle out of court, you can't go to mediation. No, that's not true. And I think I cited case law, the federal cases, explaining why when it says may, it means shall, if one of the parties presses for the arbitration. So I believe what we're trying to say here is that undoubtedly you could have resolved this dispute informally. You could have filed litigation. They did file litigation. If we just would have filed an answer, we'd be on our merry way down the court. So that's the purpose of the arbitration provision. It's a waiver. It's affirmative defense, actually, in the pleading. And by setting it up, what you are arguing is hey, hold on, folks. We aren't going to court. We're going to enforce this arbitration provision.
And that you are correct when you say that these are standard terms that we deal with all the time. The question is does the fact it says may in the notification in the front page and shall in the notification in the second page, which could just be modified how, because it says shall be governed by American Arbitration Association, mean that it's mandatory or mean that it's ambiguous? Because the court found that it was no ambiguity in that phrase.
And I agree. One, I agree that it's merely a notification, okay? No good deed goes unpunished, so to speak, right? If that wasn't in there, I guess we wouldn't have an issue. But it was put there in front of the signature lines to notify the customer, hey, there's an arbitration provision, you better look at it. That was the purpose of that notification.
Well, but like the other side said, you could have that purpose fulfilled just by saying, notice is hereby given that this contract contains an arbitration provision.
I agree.
And it's clear then, it's not ambiguous in any shape, manner, or form, that this is just a plain notice so everybody's aware of the fact.
I understand that by putting that in there, the party was attempting to tell the person signing the agreement that this may go to arbitration.
And how do we know that, or how do we know it wasn't something that was put in there in order to make sure that the parties both knew that they both had to agree, or whatever?
Well, let me throw this out to the court. Let's assume we add this provision in the contract. Warning, this is a binding agreement that may be enforced by the parties. So if we have that provision in the contract, does that mean that post-execution, one of the parties can say, oh, the contract's not enforceable? What I'm trying to say, if you use those same words, may be enforced by the parties, in that context, I think it's totally clear to everyone it's not ambiguous. When they're referring to parties, they're referring to either party. It'd be the same if you had a provision that says, this agreement contains a binding attorney fees payment provision which may be enforced by the parties. Then you read down the line and it says the prevailing party shall be awarded its reasonable attorney fees. Should the party who loses be able to argue after there's a determination against them that attorney fees provision is not binding? Same thing. It gets down to I initially thought their argument was about the may, but I think their argument is more about the parties. And the term parties means either party in that context. I don't think it's ambiguous. And that's our position. And again, I have to reiterate, not only do we think it's not ambiguous, it's just merely a notification. Telling the parties, hey, you better read the rest of this agreement and read what the language is regarding the arbitration agreement. Because undeniably, I don't think there's any dispute that the arbitration agreement is solid. They are arguing that provision right before the signature lines. Thank you.
Thank you. You have 4.5 minutes left.
Thank you, Your Honor. Just to touch on the argument about a similar attorney fee provision, which one side would pay, I don't think that is applicable in comparison, because that would obviously be after a determination was made that one side had won, and the side that won could enforce the attorney fee provision. This arbitration issue is a preliminary. It's a preliminary matter. Who can force arbitration? Can't be forced by one party. Can't be forced by both parties, which gets me back to the ambiguity argument, which I think for the purposes thus far I've covered as much as I can. Just a quick word on those federal court opinions. I think it's interesting to look at the provisions in the one Benihana of Tokyo LLC versus Benihana of the Southern District of New York. The provision there read, either party may elect to submit the dispute to binding arbitration. It was clear there that travel port, global distribution versus Bellevue Airlines, it just said that disputes may be submitted to arbitration. It was silent on which party had the right to enforce. I think this provision is unique in the sense that, you know, their arguments, it's a notification provision, but it at least has elements of an operative provision. It seems to give the choice, first off, by the use of may, that the arbitration is not mandatory. And then it just uses this ambiguous phrase, by the parties.
Counsel,
Yes.
let me ask you this if I could. You're supposed to read the contract as a whole, correct? You would agree with that?
Yes.
And I don't think you take any issue with the second provision with the shall being mandatory, if I understand your argument.
We don't take exception with the second provision if it were standing alone. So
Okay, and let me move on to the
Sure.
third prong, I guess, is what I'm trying to ask you. Ambiguity has to be reasonable ambiguity. I
Yes.
know that you know that because you put that in your brief. In light of the second provision, how is your interpretation of the first provision reasonable?
Well, again, I would have to defer to the whole contract once again, just in the sense that there's always a division between the two parties. You know, there's always a separation, seller, buyer, contractor, and this is the only area where the parties are joined. So in light of the second provision, that's where I'm getting that I believe it is a reasonable, at least a reasonable interpretation. I'm not arguing it's the only interpretation, but that it is reasonable to interpret it as arbitration by agreement of both parties.
Thank you.
That's all, Your Honors, unless any other
I
questions.
don't believe so. Thank you.
Okay, thank you.
Thank you to both sides, and the court will take the matter under advisement. We will issue a written opinion that will be sent to both sides as well, and you can also look on our website for the release and electronic. Thank you very much.
Thank you very much.
Thank you.